revision process took about a year, and we had about over 1,000 comments worldwide as part of the public consultation process and a separate process consultation with our Users Council. So it's a huge project. We are very happy to roll it out 1st of August. And the cases have been coming in, since then under the new rules, which shows us user certainty and confidence, even though there were quite significant changes in some areas. And moving to your questions, multiple contracts, multiple parties, the provisions that allow a party to file multiple notices of arbitration and concurrently file an application for consolidation under the new rules, or to file a single notice of arbitration, and that is deemed to be an application for consolidation. So there's flexibility there in terms of, and this is where counsel are important, the lawyers then advise their clients how they wish to do it, when they wish to do it, because under the new rules, it can be done pre-constitution of the tribunal, in which case the application is considered by the SIAC Court of Arbitration, or post-constitution of the tribunal, it goes to the tribunal itself. So it's flexible, and it will save parties even greater time and costs. Another new one that we have, which is the first amongst major institutional rules worldwide for commercial arbitration, is the early dismissal of claims or defenses. And this is our response to some criticisms that arbitration did not have the same equivalent as in common law systems that courts do, the summary judgment, the striking out procedures. We put it in there to give users another tool in their toolkit to save time and costs, where typically it would be the respondent, which would try and game the system by dragging out the proceedings, making them even costly and creating more delay for a claim for a defense that is manifestly without legal merit. The other limb to this new rule is a claim or defense that is manifestly without outside of the jurisdiction of the tribunal. So we put it, the way it's couched, it applies to both claims or defenses. So if you're a claimant trying to game the system, equally the respondent could apply under this procedure. And the other tweaks really are some enhancements, further enhancements to our existing emergency arbitrator and expedited procedure fast-track 6-month arbitration proceedings, which have proved very popular since they were introduced in 2010. So now we've made them even quicker and cheaper. So for example, emergency arbitrator, we've basically gone and struck out all the business from business day. So we will appoint the emergency arbitrator within 1 day instead of 1 business day now. So, and effectively, I think this is because this just reflects the ongoing practice. So the Secretariat works through the weekends, through public holidays, so why not just make it 1 day rather than have parties wait till the following Monday? And so we hope that by enhancing this and making this more flexible and quicker and more reasonable for parties, this will make SIAC and Singapore an even more popular choice for users from all over the world.